I put you on the
Okay.
Dr. Roberts, have you had a chance to read through our exhibit 183?
I have.
The very first line, affordable and reliable energy is a fundamental precursor for a vibrant and competitive New England economy. Do you agree with that?
I would say I'm not an expert on what is fundamental for a vibrant and competitive New England economy, and I think that's a very short-term perspective.
Down the last full paragraph, ISO New England has identified winter fuel security as the most significant issue facing the region. This issue affects both regional reliability and affordability, and this is the part I want to focus on. The New England states and ISO New England have recognized the challenge of increasing reliance on natural gas-fired generation during cold periods when the region's natural gas is used primarily for heating. These concerns have been heightened as non-natural gas-fired generation resources such as nuclear, coal, and oil have retired in recent years. During recent winters, ISO New England has been relying on more expensive, carbon-intensive, oil-fired units to ensure sufficient generation to meet hour-by-hour demands on our energy system. Are you familiar with that? Do you agree, disagree, have no opinion?
I'm not an expert on this, and I think this is very complicated, and this reflects only one portion of the consideration.
All right. Continuing at the bottom there on the same page and going to the next one. The states are committed to use the tools within their jurisdiction to advance solutions to the winter fuel security issue. There is no one clear solution to the problem, and each state's policy priorities will inform the solutions that states want to prioritize. For example, energy policies that can address winter fuel security include, and now I'm going to ask you some questions about the bullets. It's the fourth bullet down. Investment in siting of infrastructure for new clean generation resources, such as large-scale hydropower and offshore wind, the production of which correlates very well with cold weather periods. Do you agree with that?
Objection. The beginning of the paragraph that Mr. Blazer read makes clear that we're talking about the ISO's winter fuel security issue. Mr. Blazer's jumping off point was Dr. Roberts' Exhibit B to his original testimony, which is the New England Governor's Eastern Canadian Premier's Climate Change Action Plan. As Mr. Blazer brought out correctly, Dr. Roberts is testifying about climate change. The fact that there's an exhibit from the New England governors does not make every statement ever issued by the New England governors on ISO's winter fuel security issues fair game for cross-examination.
I think that might be the longest relevance objection I've ever heard. But with that said, if he wants to clarify any of this on redirect, Mr. Elmer certainly can. I'm entitled to ask this witness, since he has identified the source of this document as an authoritative source, whether or not he agrees with some of these statements.
I'll allow that.
Thank you. I'll read it again, Dr. Roberts. Again, with the background of that initial leading paragraph that leads into these bullet points. Investment and siting of infrastructure for new clean generation resources, such as large-scale hydropower and offshore wind, the production of which correlates very well with cold weather periods. Do you agree with that?
I actually am not an expert on that, and I don't know. I don't think I can answer that in general terms. Of course, I think it sounds good.
You do agree, obviously, that increased penetration of renewables is a good thing.
That's the goal.
Okay.
That's one of the goals.
Working with congressional, next bullet, I'm sorry. Working with congressional delegations to address whether the Jones Act should be modified to ensure that LNG, that's liquid natural gas, right? That LNG can be delivered in a timely manner during winter months. Do you agree with that policy statement?
I have no opinion on that.
Next one, examine state permitting options that would optimize the use of dual fuel units to meet operational fuel security needs while maintaining state environmental requirements. Do you agree with that policy statement?
Sure.
Bless you.
I have no opinion on that.
And the last one, examining potential additional infrastructure, including bless you too, including natural gas storage in key areas that could be used by gas-fired generation. Do you agree with that policy statement?
I have no opinion on that.
All right. We're done with that one. Okay, that's 183. I'll move 183 as full.
Previous objection.
Wow, that
All right,
183 spoke.
let's turn to accounting.
Okay.
My colleague, Ms. Noonan, just said how exciting, right? My son's an accountant. Whenever he talks to me about what he's doing, my eyes just glaze over. But there is, I think we can all agree, you would agree, a fundamental disagreement between you and Mr. Hardy and OER about how to account for carbon. Is that a fair statement?
I can't really speak for those parties. There does seem to be some apparent disagreement. I think there's maybe some of the disagreement is about when one should apply consumption or production-based accounting methods.
So, if we are to take any instruction from what went on Tuesday, would you agree with me that there is in your mind, and clearly in CLF's mind, a dispute or disagreement about the appropriate use of consumption versus production-based accounting?
Yes.
Is that a fair statement?
Yes.
All right. Let's go to your pre-filed rebuttal. And I'm not going to ask you quotes. I'm referring to pages 2 to 6 of your pre-filed rebuttal. And would you agree with me? This is where you talk about why you believe production-based carbon accounting is the more appropriate method. Is that correct?
Pages 2 to 6.
I believe that's what my notes reflect. I hope I'm right.
It doesn't look like you're looking at the rebuttal.
It's the rebuttal, I'm
supplemental,
sorry.
Or the rebuttal.
Right, I
Sorry,
apologize.
I'm just using a different.
Okay.
Oh.
Pre-filed rebuttal testimony.
Right.
Yes, subject to check, yes, I think this is mostly where I
good.
talk about this.
Mr. Blitzer,
Yes.
I don't want to try your case very bad. Just, maybe you want to start just on page 1, at the bottom of page 1, where the caption heading says consumption versus production-based carbon accounting.
You feel free to try my case anytime you want. Thank you. Appreciate it. All right. We're in the right ballpark. Do you agree with me, Dr. Roberts, that climate change is a global problem?
Yes,
And in part, it's a global problem because greenhouse gas emissions in one state or one country do not stay in that state or that country.
yes,
So in other words, you do agree that greenhouse gas emissions do not respect geographic borders?
yes,
This is just exemplary, but if we can pull up, Ms. Verdi, the September 17 article. This, while testimony was going on Tuesday, I'll admit I was surfing the web and found this article.
This will be for IT and Energy Exhibit 184.
Let's just stay with the front page, please. Thank you.
Mr. Blazer, what is this about? What publication is this from?
This is from, bear with me 1 second and I'll find it for you. I just saw that on this version, it doesn't say it, so. Inside Climate News. And it's from Tuesday. Would you? I don't know if you do or not, Dr. Roberts, but maybe those of us who are involved in the climate change issue. Inside Climate News is one of the publications that we look at, correct?
Yes, it's one of many.
Right. It certainly is. So this one, this is really just exemplary. It talks about states begged EPA to stop cross-state coal plant pollution. Wheeler just refused. We won't get into the political debate right now. We've had an enjoyable conversation about it offline. This is, though, an example of what we're talking about here, cross-state pollution, right?
Objection. Mr. Blazer has gotten Dr. Roberts fairly to say that CO2 doesn't respect geographical borders. An article that nobody in the room has read except Mr. Blazer, to start asking detailed questions about that, I think it's unfair and improper.
I also object. Newspaper articles under Rhode Island Supreme Court pronouncements are clearly hearsay and are not admissible.
I haven't moved to admit it, Chairperson. I'm simply asking him if he agrees that this is an example, that this subject of cross-state coal plant pollution is an example of the fact that pollution doesn't respect borders. That's all.
We have his answer that is the case, that CO2 does not respect state borders. I object to Dr. Roberts being asked questions about articles that neither he nor anybody else in the room has read.
Well, if he wants to take the time to read it, I have no problem. If that's the objection, then by all means, I'd say Dr. Roberts read the article.
Although he has already, has he not, said that he agrees that indeed climate change is a problem that respects no boundaries, state, federal, or country.
And the article's about smog.
Right. Understood. All right, I'll move on. But am I correct? We can take this one down. Am I correct, Dr. Roberts, that you do not agree with the proposition that since ISO New England is a single unitary electric grid, that reducing CO2 emissions is most appropriately viewed on a consumption basis? Is that right?
The law of the land is based, in my opinion, on production-based emissions accounting, and that has always been the standard way for accounting emissions by state, by country. It's the only way. It's what everybody has always used.
And you said it's the law of the land.
I did.
Okay. In fact, it's your position that using consumption-based accounting is an accounting trick. Is that right?
That is my opinion.
Right. That's in your...
Wait, let me be clear. That is consumption-based accounting of electricity generation that only includes the carbon emissions from the generation and then divides it by what proportion of emissions or that of that electricity are actually consumed within the state of Rhode Island. In this case, about 6.1% of the New England grid. I consider an accounting trick in the sense that it has changed the rules after the law was passed, and it undermines the intent of the legislature of the state of Rhode Island, which was to use production-based emissions accounting, which has always been the case.
All right, well, let's look specifically at what you've said about this accounting trick. It's your rebuttal testimony. Hope we're using the same version.
Yeah.
My notes say page 4, starting at line 20. Let me know when you're there.
Over there.
If you use consumption-based accounting, as OER mistakenly does, then Rhode Island could build a retrograde coal-fired power plant in downtown Providence without violating the law calling for carbon emission reductions, because by this neat little accounting trick, 94% of the plant's emissions would count toward emissions of states outside of Rhode Island. Did I read that correctly?
Yes.
And are you aware that Rhode Island is in fact often an importer of electricity? That Rhode Island is using electricity produced in other states?
I am not aware of the net and how. I'm not aware of exactly how that ends up. You know, are you talking about a year? Are you talking about every day? Or I don't know.
Are you aware of it all? Does Rhode Island import any electricity from other states?
Yes.
Ever?
Yes.
Okay. And then looking at your rebuttal, this is page 6, starting at line 10. In support of your position, you rely on the Massachusetts Supreme Court decision that my colleague Mr. Elmer spent so much time on Tuesday, Kane versus Massachusetts Department of Environmental Protection, correct?
Yes.
All right. And you say here, in Kane, the Massachusetts Department of Environmental Protection argued exactly as OER does in this case, in favor of consumption-based accounting. Conservation Law Foundation, representing the plaintiffs, argued for production-based accounting. The Supreme Judicial Court of Massachusetts sided with CLF and the plaintiffs. Did I read that correctly?
Yes, you read that correctly.
So from your perspective, using the words you used a few moments ago, the decision of the Supreme Judicial Court of Massachusetts would be the law of the land?
That's not what I said. I said that the assumptions made by the Executive Climate Change Coordinating Council when they adopted the use of consumption-based accounting in the 2016 Greenhouse Gas Emissions Reduction Plan, which was required by the Resilient Rhode Island Act of 2014, that they pointed to their neighboring states as having adopted or adopting very soon consumption-based accounting, which I believed at that time, and I told them repeatedly at the EC4 meetings, at stakeholder forums held by this committee that was developing the Greenhouse Gas Emissions Reduction Plan, that it was not a responsible use of consumption-based accounting, that it was selectively done, that it was not the law of the land, that they were ahead of the law by adopting that approach, and that our neighboring states, in fact, have not adopted that approach. And so to do so is, in fact, an accounting trick. Who's going to take responsibility for those 94% of emissions if we say we only have to count 6% of the nearly 7 billion pounds from the correct facility? Who's going to take responsibility for those? I would argue that that's not going to happen if we're all using accounting that is convenient for us in the state of the fact that we're unlikely to meet our targets that we've made, which are themselves entirely inadequate according to the science of climate change.
Thank you, Dr. Roberts. I'm just focusing on what you mean by the law of the land. From your perspective, since you seem to you have an understanding of what you mean by the law of the land, in Massachusetts, where the Kane decision was rendered by the Supreme Judicial Court of Massachusetts, the highest court in the state, is the Kane decision part of what you consider to be the law of the land in Massachusetts?
Oh, in Massachusetts?
Yes.
I am not an expert on the law of Massachusetts.
Okay.
My understanding is that these briefs included arguments, and I'd be happy to point to the the places in those briefs in which they talk about consumption and production-based accounting. And I would say that those briefs then become, I mean, I'm not a legal expert either, but they become the legal precedent by which the state of Massachusetts cannot use consumption-based accounting. In this case, and as I understand it, the selective use of consumption-based accounting for just the electricity sector and just including the combustion of those fuels and not the upstream emissions and so on. All these other parts that need to be part of a real consumption-based accounting system.
Let's delve into that a little bit further, because you had said, I made a note here to myself when you were testifying, I think in response to Mr. McElroy, you had said that you had read some of the briefs, including the CLF brief that had been submitted in Kane, correct?
Correct.
Have you ever actually read the Supreme Court decision?
I have not, and I understand though that it does not include a reference to this part of the argument.
I see. So your understanding is that the arguments of the parties that were submitted to the Supreme Judicial Court of Massachusetts are the law of the land in Massachusetts, regardless of what the Supreme Court ultimately said about those issues?
Again, I'm not a legal expert, especially not in the state of Massachusetts.
How did you originally learn about the Kane case?
I had heard about the Kane case from news reports. Some of the same news outlets that you mentioned. I visit those same sites.
Okay.
An important outlet. I also learned from the Conservation Law Foundation.
I'm going to read you a quote, and I'm going to ask you if you agree with it. It was determined, if you know. It was
Where is this quote from?
It's actually from Mr. Elmer's opening statement. It was determined by the Massachusetts Supreme Court in the case of Kane versus Massachusetts Department of Environmental Protection, 474 Massachusetts 278, a case, of course, brought by CLF. One of the issues in that case was consumption-based accounting versus production-based accounting, and the court ruled that CLF was right, that you have to do production-based accounting when you have a statewide regulatory scheme limiting statewide emissions. Now, and I want to be very clear about this, I'm not trying to trick you here, but you actually don't know whether that statement is true or not because you've never read the Kane decision, is that correct?
I have not closely read the Kane decision.
I'm looking at this page, I think Kane is spelled K-A-I-N. That's another correction that
Right.
needs to be made.
That's in 2 locations on that page. Or 3.
Thank you, Madam Director.
Can we get, please, Ms. Verdi?
Since there's been so much discussion about Kane between Tuesday and today, we've actually, I don't think we need to submit it as an exhibit. You can probably take administrative notice of it, but I think everybody should have it. So Ms. Verdi is going to be handing it out.
Mr. Elmer, do you have any objection to us taking administrative notice of that?
No, I was actually going to move that myself. I would be delighted if the EFSB takes administrative notice of Kane and of the subsequent Section 3D regulations promulgated by DEP after Kane, which I discussed on Tuesday. I will provide a copy of those 3D regs to the board, together with my request that the board take administrative notice both of the Kane decision and of the subsequently promulgated regs.
Oh, we did?
Possibility may exist. We'll still be covering a bit of that in my cross-examination.
All right, well, certainly at this time, to the extent not otherwise previously, we will take administrative notice of Kane.
Now, to be fair, you have never read this document or this opinion before, correct?
Correct.
All right. So I'm just going to point you somewhere, then I'm going to ask you a question, recognizing that you haven't read this before. If you could go, this is the Westlaw printout?
Yes.
All right, so it's page 12 of the document, not necessarily page 12 of the opinion, but the pages are numbered. Do you see that?
I do in the bottom
Right,
right.
bottom right, okay. it's on the left-hand column. Let's see if I can, here we go. It's the middle of that top paragraph, although it's not a full paragraph. You'll see it's kind of in the middle of that paragraph. It starts, moreover, GLC 21N section 3 paren C specifically carves out. Do you see that?
I see that.
Okay. Specifically carves out a separate process by which emissions levels and limits associated with the electric sector are established in consultation with the Secretary and the Department of Energy Resources and are to take into account the Regional Greenhouse Gas Initiative, RGGI. You see that?
I do.
And you see then there's a reference to a footnote 23,
Yes.
and that's on page 15 of this printout. If you can go to there, see toward the bottom there's footnote 23.
Yes.
General laws, 21N, section 3C, requires that, quote, emissions levels, and let me stop there for a second. Do you know what General Laws, Section 21N, Section 3C refers to?
Objection. The EFSB has taken administrative notice of the Kane decision and the DEP regulations promulgated after Kane was issued. Dr. Roberts has not presented himself as a lawyer, as an expert on reading cases or interpreting cases that he's never read before. As lawyers like to say, the Kane decision speaks for itself. The board has taken administrative notice of the decision, and it speaks for itself.
Right. Well, and I've objected before to Mr. Elmer's speaking objections, but even if we ignore that, this witness, under oath, in his pre-filed testimony, said the following. I read it before, but I'll read it again, because I know Mr. Elmer doesn't want to go down this road. In Kane, this is rebuttal page 6, starting at line 10. In Kane, the Massachusetts Department of Environmental Protection argued exactly line 15, I apologize. In Kane, the Massachusetts Department of Environmental Protection argued exactly as OER does in this case, in favor of consumption-based accounting. The Conservation Law Foundation, representing the plaintiffs, argued for production-based accounting. The Supreme Judicial Court of Massachusetts sided with CLF and the plaintiffs. He is speaking directly about what this case purports to say. I'm entitled to cross-examine him on it, whether or not Mr. Elmer likes it.
And I'm sorry, what was the question?
The question that was pending was, does he know what General Laws 21N Section 3C refers to?
I think that's allowed. You can answer that.
I do not.
I could have just a moment, Chairperson. You know what the Massachusetts Board of
Please turn your microphone.
Do you know what the Massachusetts Global Warming Solutions Act is?
I have read the 2008 Global Warming Solution Act of Massachusetts, but it's been years.
All right. Well, would you agree with me in the context of what you've been saying, that the GWSA is the law of the land of Massachusetts?
Yes.
All right. So let's continue with this footnote 23. General Laws 21N Section 3C requires that emissions levels and limits associated with the electric sector shall be established by the Executive Office and the Department in consultation with the Department of Energy Resources based on consumption and purchases of electricity from the regional electric grid, taking into account the regional greenhouse gas initiative and the renewable portfolio standard. Did I read that correctly?
Yes.
Who told you that Kane overturned this statute?
I don't,
Objection. Dr. Roberts has not testified that Kane overturned the GWSA.
We've already gone over what Dr. Roberts has testified to, and he said, I'll repeat again, the Supreme Judicial Court of Massachusetts sided with CLF and the plaintiffs. So my question stands. Who told you that the Supreme Judicial Court of Massachusetts overturned the global warming, or Section 3C of the Massachusetts Global Warming Solutions Act?
Objection.
Did Dr. Roberts testify to that particular item, or was he talking about which position was rejected by this decision?
Well, I'll read it again, Chairperson. I think it's important.
Because I don't recall that we have in the record a statement from this witness that this case overturned the act.
Let me try it a different way, if I may. Now, I'll lead into it again with the testimony that he's provided in this case. I'll read it one more time. I think it's a very fair point. In Kane, this is your testimony. In Kane, the Massachusetts Department of Environmental Protection argued exactly as OER does in this case, in favor of consumption-based accounting. Conservation Law Foundation, representing the plaintiffs, argued for production-based accounting. The Supreme Judicial Court of Massachusetts sided with CLF and the plaintiffs, sided as S-I-D-E-D, with CLF and the plaintiffs. So let me try it a different way. I think the chairperson made a fair point. Who told you that the Kane decision rejected consumption-based accounting and adopted production-based accounting?
I was briefed by Jerry Elmer of the Conservation Law Foundation about the Kane decision. I have also sought out other input on that case. I would also like to comment that this footnote 23
I'm
does
sorry,
not
there's no
make clear
question.
that
There's no question pending. He's answered the question.
I think we should let the witness fully answer the question and not cut him off in mid-sentence.
I think we will let him just finish that.
My observation is footnote 23 argues that there is actually like many places, there is the wish for regional-based solutions, such as the Regional Greenhouse Gas Initiative, or RGGI, the Renewable Portfolio Standards, etc., and these Northeast governors and Eastern provinces premiers. We all want regional solutions, but that's not the way our state targets are set, and that's not how we're going to be able to measure whether we're meeting them.
I'm sorry, Dr. Roberts. So are you referring to the Global Warming Solutions Act as an argument and a wish?
I am not.
Okay. Since Mr. Elmer appears to have been the source of all of this for you, has he provided you with any more recent statements of Massachusetts law on the issue of consumption versus production-based accounting?
Just not.
This is another case I think is going to be the market user.
For the record, what we've distributed, which we're asking the board to take administrative notice of, is the September 4, 2018 decision by the Supreme Judicial Court of Massachusetts in the matter of New England Power Generators Association, Inc., and others versus Department of Environmental Protection.
If Mr. Blazer had not requested that you take administrative notice of this, CLF would have. We certainly do not object.
Any of the other parties object to us taking administrative notice?
No objection.
We take administrative notice of the matter that you just introduced.
Thank you. Okay, and for the record, there is no official site yet. It's a slip opinion because it's so new. So I'm not going to ask you to read the whole thing, Dr. Roberts. As you can imagine, as you can expect, I'm going to point you just a few sections of it, unless you want to read the whole thing. I don't want to stop you from doing that.
Funny guy.
I'm a little concerned about your pointing me to certain.
Dr. Roberts?
I'm a little concerned about your pointing me to certain sections, but I'm happy to look at those sections you might be doing.
Let's go question by question. If you're uncomfortable, I will move on. Okay? So this starts at pages 5 to 6. It's the first full paragraph on page 5. It starts, the Act defines. Do you see that?
Yes.
And again, what's being referred to here as the Act is the GWSA. The Act defines statewide greenhouse gas emissions as the total annual emissions of greenhouse gases in the Commonwealth, including all emissions of greenhouse gases from the generation of electricity delivered to and consumed in the Commonwealth, even if that electricity is produced elsewhere. Then there's a citation. Massachusetts is served by a regional electric power grid that includes 6 states and is interconnected with the regional grids of New York and 2 Canadian provinces. Most relevant to the instant case, the Act also empowers the Department, in consultation with the Executive Office and the Department of Energy Resources, to set emissions levels and limits associated with the electric sector based on consumption and purchases of electricity from the regional electric grid, taking into account the Regional Greenhouse Gas Initiative and the Renewable Portfolio Standard. I'll stop there. Has Mr. Elmer ever mentioned this case to you?
Objection. If the chair will give me a standing objection, there'll be fewer interruptions. The board has taken administrative notice of this case. CLF will certainly point to this case in its post-hearing memorandum. But the case does speak for itself, and CLF objects to cross-examining Dr. Roberts on a case that is dated September 4th, that he has never read, that was issued after Kane. It's true that Dr. Roberts mentioned the Kane decision in his testimony. This case hadn't even been filed when Dr. Roberts' testimony was filed, let alone decided. Administrative notice has been taken. We'll argue the case, but the case speaks for itself.
Could I just say the time for bringing up cases is at the briefing stage. I have not had a chance to read this. This is not fair for Dr. Roberts. He has not had a chance to read it. The people sitting in this room have not had a chance to read it. Briefing is when this is done. So I object.
I would agree with my brother, Mr. McElroy, that this is normally not the place to bring up cases, but for the fact that Dr. Roberts and Mr. Elmer have made so much about cases, or at least a particular case, in Massachusetts, and what they contend is the law of the land in Massachusetts. They are the one who have the ones who have put the law of Massachusetts into issue. And I believe we are entitled to explore what it is that Dr. Roberts, I apologize, does or does not know about what he referred to as the law of the land in Massachusetts.
I don't know what you're trying to get at by asking. I believe the question that was pending is whether or not anyone told the witness about the paragraphs that you just read. I don't know what relevance that has to what we're doing. And I also think I have a problem with asking this witness questions about sections simply plucked out of a decision which admittedly no one else has read. So I think this is not really a great
Fair enough,
question.
Chairperson. Fair enough. Just following on that last comment you made, I have a feeling now everyone will read it. So I'll move on. Thank you. Other than some briefs that were filed in Kane, Dr. Roberts, are you personally aware of any other part, condition, statute, or anything else under Massachusetts law that supports your and CLF's claim that carbon accounting in Massachusetts is production-based?
I think a more maybe complete answer to that question would be that I'm aware of some of Massachusetts' approach to climate change and its accounting. I think I will refer to the the case that you just handed us to say that Massachusetts is still working out how it's going to account for carbon emissions, that this is still under dispute, and for Rhode Island to say that this is the way everything is going in our region and that therefore we should adopt this approach is not a logical or really fact-based assertion.
Now, in one of the objections, Mr. Elmer had mentioned the Massachusetts regulations, how Massachusetts accounts for emission factors. Have you ever reviewed those regulations? Have you ever reviewed any description of those regulations that supports the proposition that Massachusetts is accounting for carbon via production versus consumption?
I have not, honestly. I mean, there's been some, I've looked into this in some, in broad terms, but I have not reviewed their regulations in detail, no.
All right. I'm going to show you something just to see if you've ever seen it. If you haven't, tell me, and we'll cut off a page and cross-examine.
This will be marked for identification. Let's move them to 185.
Yes, for ID. And for the record, Dr. Roberts, this is a document dated May 2018, or just earlier this year. Greenhouse gas emission factors to be used by retail sellers of electricity, reporting under a particular regulation in Massachusetts. Have you ever seen this before?
No.
All right. Completely unfamiliar with it?
Correct.
I'll ask you no questions about it. Thank you. All right, let's move on from Massachusetts and cross the border into Rhode Island, shall we? I want to go back to one of the directives that this board gave to OER when it asked for the advisory opinions. Just so we know the lay of the land here. This board directed OER in collaboration with the Executive Climate Change Coordinating Council, EC4, and with assistance from DEM, to render an advisory opinion as to the impacts of the facility on anticipated greenhouse gas emissions that would result from the proposed facility and the cumulative impact over the life of the project. That's the framework we're working with, okay? All right. Now here's what you say. This is your rebuttal testimony. Page 8, starting at line 18. Everybody there? The irony then is that I am a strong endorser of utilizing such a consumption-based model to account for carbon emissions, as the term is properly used in the academic literature. Here, although I respect my colleagues in the Office of Energy Resources and want to support their efforts to green the economy of Rhode Island, OER is essentially using an accounting trick to pretend that building a large, new, long-lived fossil fuel power plant in Rhode Island will actually result in Rhode Island being able to meet its targets under the Resilient Rhode Island Act. That is preposterous, and I think the selective use of consumption-based accounting is plainly disingenuous and against the intent of our legislature and the previous governor who signed the act into law. Can you stand by those statements today?
I do, very much.
Okay. That word disingenuous, that's a pretty strong word, wouldn't you agree?
I agree.
Webster's defines it as not truly honest or sincere, giving the false appearance of being honest or sincere. Is that your intent in using the word disingenuous?
Yes.
So you're accusing Dr. Kuhl and OER of being dishonest?
I am arguing that their decision to advance the adoption of a whole new set of accounting rules after a massive power plant has been proposed, including with the support of the governor, who is of course the head of, the employer of these department heads and their staff, that there was an effort to find numbers that would allow them to argue that this plant would still allow the state of Rhode Island to meet its goals under the Resilient Rhode Island Act. And I think there has been tremendous effort to be able to make that case, and I have not yet heard who's going to take responsibility for those 94% of the 7 billion pounds. Who's going to take responsibility for those in their state plans? That is not, from my understanding, and much of it is indeed based on incomplete understanding of the laws of all the 6 states in the ISO New England region, that those states are not going to take responsibility for the Clear River Energy Center 7 billion pounds of emissions, because they have their own targets that they're having difficulty meeting. So I think there's been a great effort to find numbers that will allow the state agencies to argue that this plant somehow improves our ability to meet an act that was passed in 2014 under the previous governor.
Could I ask the court reporter to read my question back, please?
So you're accusing Dr. Kuhl and OER of being dishonest.
Could you answer that question now, please?
It's been asked and answered at some length.
It has not been answered.
I thought that was answered.
I don't
Is there, what follows?
That whole soliloquy that he just gave, he didn't answer my question.
I believe that if the stenographer reads back the answer, the chair will be able
Well,
to make a
let's-
suitable reading.
you can-
ruling.
Ask, it's a yes or no question.
It is a yes or no question. Are you accusing Dr. Cool and OER of lying?
Objection, lying is not.
Of being dishonest? Are you accusing Dr. Cool and OER, within the confines of the definition of disingenuous, of being dishonest?
I am asserting that their actions were disingenuous.
And therefore dishonest?
I think that's enough.
All right. Was Dr. Cool being dishonest when she testified here on Tuesday?
I cannot comment on that.
Why not?
I am not Dr. Cool.
I'm asking for your opinion. In your opinion, was Dr. Cool lying when she testified here on Tuesday?
Objection, asked and answered.
I think you want to move on.
Was Dr. Cool specifically being dishonest when she made it clear that Massachusetts has not adopted production-based accounting as Mr. Elmer kept claiming on Tuesday?
I don't know.
All right, let's see if we can figure out what Rhode Island has actually done. This is the
PhD study recommendation. February 2, 2016. Yes.
So this will be marked for identification as being under A186.
I have that document?
Yes, I do.
Dr. Roberts? Okay,
Yes.
thank you. It says the February, for the record, February 2, 2016, GHG study recommendations to Office of Energy Resources. I'm just going to read you some things and ask you some questions.
I'd like to enter an objection at this point in time. I understand what my brother is trying to do, but I disagree with it. There's a reason we pre-file testimony in these dockets. We pre-file it so that there's a level playing field. Everybody gets the opportunity to review the cases that have been made. And these hearings are solely for the purpose of cross-examination on the pre-filed testimony. And what my brother seems to forget about that is that that means that your case has to be put in. And my brother is now attempting to put in more of his case. Last minute, didn't even tell us yesterday that this was coming in. It comes in during the middle of the cross-examination. It violates the rules of this board, the fairness rules of this board. I don't know what this says. I haven't seen it before. But look at the date, February of 2016. How long has the pre-filed testimony been in? Well over a year. If he wanted to counter this, he had a chance to file rebuttal testimony. This 2016 document existed at the time his witnesses filed their rebuttal. He could have brought it to our attention at that time, and we would have been educated enough to be able to properly deal with it at these cross-examination hearings. This is not the way cross-examination is to be conducted on previously filed testimony in this matter, and I object to it continue. And I object to this document.
If I may, Chairperson, I'll refer to Dr. Roberts' rebuttal testimony, page 3, starting at line 18. I'll wait till you get there. Question. Are you aware of the fact that in interpreting the Resilient Rhode Island Act, the Governor's Executive Climate Change Coordinating Council, EC4, considered this question and decided to adopt the consumption-based method of accounting? Answer. Yes, I certainly am. That decision was made against the strongly expressed advice of some of us on the EC4's own expert panel and in repeated public comment in meetings of the group charged with overseeing public input on the study and against the strong and united opinion of the entire Rhode Island environmental community, etc., etc. It's in the record, it's proper cross-examination to ask him about what he's testified about with respect to the document we have in front of us.
How do you respond to that?
We don't do things this way. We don't bring up documents that people have never seen before and expect them on the fly at the hearing to review them for the first time. If you've got something you want to produce to the parties, that you can produce it in advance. I mean, it could have been given to us a week ago. It could have been given to us yesterday. Instead, we're getting cases, we're getting regulations, we're getting memos, all of which have been in existence for some time. And we're being asked to then deal with those at this hearing. I've never been in a situation where it's done that way before. I object. I believe it's against the spirit of the rules that we have that require the pre-filing of testimony. And frankly, it violates the collegiality rule. My brother and I think, have been very good in terms of collegiality, and I don't think that's going to change. But I do think it's inappropriate to, at the last minute, spring this stuff on people and expect them to intelligently respond. Whether or not this power plant gets licensed is a huge decision for the state of Rhode Island and for the people of Oroville that I represent. This is not the way we should be trying this.
Chairperson, CLF is deeply ambivalent about this for the following reason. Dr. Roberts was involved in those discussions and deliberations at the EC4. I would like him to be able to speak about those deliberations from his own personal, first-hand knowledge. That discussion is fair because he did testify about them in his rebuttal testimony. The quote from Dr. Roberts' rebuttal testimony that Mr. Blazer read is fair and accurate and correct. And it would be proper cross-examination for Mr. Blazer to ask about the quote, what did you mean, what is the basis of the quote, why did you say that, who disagreed with you. Instead, we get trial by ambush. We get new documents that are dated years ago that could have been provided. Invenergy's witnesses could have referred to them. They could have incorporated them as exhibits. Proper cross-examination is on the pre-filed testimony. Trial by ambush, we don't allow anymore.
I would agree that this was an ambush, but for the fact that this witness has submitted pre-filed testimony talking specifically about this process, the process that led to this document, the process that led to the publication of the report in December of 2016. It's all in the record from this witness, and it's
right. But the witness is talking not about this specific document, which nobody's had a chance to read yet. And so I do think it's inappropriate to ask a lot of questions now without anyone having had an opportunity to read through this. I don't think, however, you are precluded from asking as many questions as you like on what the witness has said about whether Rhode Island has or should have adopted the test that he believes should have been adopted what the test is, the aspects of the different tests. I think all of that is fine.
And that is exclusively what I intend to do, Chairperson.
Well, can you do it without this memorandum?
I don't know how, because this memorandum talks about all of those things, and Dr. Roberts has made it clear that he was part of this. He was personally engaged in this.
He hasn't made it clear, though, that he's part of this memorandum.
All right. Maybe I'll ask
I
him
haven't
first.
read it.
Okay.
Chairperson,
I'm not, and I would, I know that all of the council are certainly aware of the fact this is only a quasi-judicial board. We're not a court of record, and we do want to get before us all the relevant evidence to all of the questions that are before us in this particularly momentous matter. So yes, I want to read this, I want to look at it. I don't have a problem with it necessarily getting into the record. I have a problem with asking a lot of questions about it right now.
And that's fair if we can get it into the record. Chairperson, I was just going to say Madam Chair, I apologize. Chairperson,
Chairperson, could I just make a statement for the record? I agree with, I'm sorry.
I wasn't-
You want it done? I'm sorry.
just one
Go
second.
ahead.
Just 1 second. If we can agree to just put it into the record, since it clearly relates to this witness's testimony, you can all read it for yourselves. It does speak for itself, and I won't ask him any more. Assuming that he's never seen this document before, we really haven't gotten there, but assuming he hasn't, I won't ask him any more questions about it, and if it's in the record, then you're free to read it. And that's really the critical thing here, that the members of this board read this document.
Chairperson, could I make one more statement? What I was referring to in this was a generalized objection that I was making about the manner in which this case was apparently being tried at this point in time, and has been prior to now. The rules of this board are clear. Rule 1.12, parens little c, testimony and evidence. Not later than 10 days before the commencement date of the final hearing, each party shall file with the coordinator all direct testimony in writing and copies of all documents and other evidence that the party proposes to introduce at the final hearing. Except for good cause shown, the board will not receive direct testimony, documents, or other evidence that has not been pre-filed as required above, end quote. That's the practice I'm used to. It's the practice, it has a good reason behind it, it prevents...
Surely, Mr. McElroy, given the area of questioning we're currently involved in, whether or not the state of Rhode Island uses or should use the consumption method of accounting for determining greenhouse gas emissions and what the Resilient Rhode Island Act says. This is certainly directly related to that. I do agree that asking questions about a document that no one has seen, that's fairly lengthy. It's not good.
And I completely agree. My point, and again, my objection is a general one, not necessarily to this document, because I haven't read it. I don't even know what it says. So I'm not making a specific objection to this. I'm making a generalized objection to the method in which the cross-examination has been taking place. It violates this rule. It does have a good cause exception, and if my brother can make a good cause showing that he couldn't have filed it in accordance with the rules, or that the board for other good cause feels that it's appropriate to consider it, I understand you have absolutely that power. But my feeling and my practice has been that when you're dealing with legal documents, whether they be statutes, cases, regulations, state memos, etc., that's done at the briefing stage after the evidence is done. We don't do that through witnesses.
Sure. If I may add a word.
One, only.
Touche. The record will reflect that Dr. Roberts, in his pre-filed rebuttal testimony, has already responded at length to all of the following questions. What is the alternative to consumption-based accounting method that OER and Dr. Kuhl endorse? What is the difference between consumption-based and production-based accounting for carbon? Why do you believe the production-based accounting method is more appropriate in this case? Are you aware of the fact that interpreting the Resilient Rhode Island Act, the Governor's Executive Climate Change Coordinating Council considered this question and decided to adopt the consumption-based method of accounting? Is there another reason why you favor production-based accounting? Does the phrase consumption-based accounting for carbon emissions have a specific meaning in the academic literature pertaining to climate change? Dr. Roberts' answers to these questions go on for pages and pages and are in the record and are perfectly fair game for cross-examination. But we object to trial by ambush.
Chairperson, a portion of what Mr. Elmer just read highlights the point. This document comes as no surprise, at least to Mr. Elmer and to Dr. Roberts, because they were part of it. This is what his testimony is about. There is no surprise here. There is no ambush. It's the mere fact that they chose not to put it in with their testimony, and we're entitled to cross-examine him about it. But again, given your admonition, let you try my case for me. If we can simply allow this to come into the record, and we certainly agree with you, whether and why Rhode Island has chosen to adopt consumption-based accounting as the method to address carbon is a critical issue. That's what we've been what we dealt with on Tuesday, what we dealt with today. We've already learned today that statements about the law of Massachusetts were based on an incorrect assumption regarding what a case said. So the record in this case screams for this document to be in it.
Well, I'm not sure I hear the record screaming at the moment, but I do agree that it's relevant, and certainly if you look at the memo on consumption versus generation methodology, it's clear. It's just the problem was only with asking questions about it right now before anybody's had a chance to read it. And it seems that Mr. Elmer provided a pretty good outline of how to elicit all of that information from this witness in line with precisely what he testified to in the rebuttal.
Well, I dare say, especially if you're going to just let the document in, I have no problem with you trying my case. I have a significant problem with Mr. Elmer trying my case. But with that said, if the document's coming into the record, then I don't need to ask this witness any more questions about it.
I'm still not letting it in for any reason until I read it.
All right, then for ID at the moment, and I suppose we can take it up afterwards, theoretically. Dr. Roberts, do you know what NESCAUM is, N-E-S-C-A-U-M, the Northeast States for Coordinated Air Use Management?
They're a consulting firm in Boston, I believe.
Let me read this to you and let me know if you're familiar with this. This is from their website. NESCAUM is a 501c3 nonprofit association of air quality agencies in the Northeast. Our board of directors consists of the air directors of the 6 New England states: Connecticut, Maine, Massachusetts, New Hampshire, Rhode Island, and Vermont, New Jersey, and New York. Our purpose is to provide scientific, technical, analytical, and policy support to the air quality programs of the 8 Northeast states. A fundamental component of our efforts is to assist our member states in implementing national environmental programs required under the Clean Air Act and other federal legislation. Does that sound familiar?
No.
All right. Have you ever dealt with anybody from NESCOM?
I heard presentations by NESCOM at the EC4 greenhouse gas emissions reduction study, which took place over 2016.
Have you ever found any of the people that you're familiar with from NESCOM to be disingenuous or dishonest?
I cannot reflect on that.
I have here, Dr. Roberts, you may remember this from Tuesday. This is the initial version of CLF Exhibit 16 that Mr. Elmer had distributed. It's a portion of the October 8, 2015 Energy 2035 Rhode Island State Energy Plan. Remember that?
Yes.
You have that? You have it.
Yep.
There you go. And you recall that on Tuesday, Mr. Elmer repeatedly stated that this document utilizes production-based accounting. Remember that?
Yes, I.
Okay. Chairperson, with fear of incurring your ire, but I have to do it, I need to refer Dr. Roberts to just one portion of this Exhibit 186, just to lead him to something else, not to ask him questions about it, if I may.
Is there perhaps a way you could just incorporate what's stated somewhere in the memorandum into a
Exactly.
yourself?
Yes, that's what I intend to do. So, attached to this February 2, 2016 memo, Dr. Roberts, is a memorandum from Mr. Paul Miller at NESCOM, dated January 25, 2016. You see that?
Yes.
All right. And at the bottom of page 4 of that memo, and the top of page 5, it talks about the consumption-based greenhouse gas approach. Do you see that?
Yes, I think that's page 4 of the two memos combined, is that right? So it's not page 4 of that one?
It might be, yeah. Well, it says page 4 at the bottom.
Yep.
You know where I'm referring to?
It says B, consumption-based.
Okay. And at the end of the paragraph, at the top of page 5, the last line, it says, well, I have to read before it actually, it's still at the bottom of page 4. In contrast, most policies which influence the type, location, and scale of generation, e.g. air quality standards, interstate transmission, reliability requirements, are federal or regional policies. Even renewable energy policies, which are state-based, are effectively implemented at a regional level. Market for RECs is New England-wide. In recognition of this, Rhode Island has recommended in its Energy 2035 Rhode Island Energy Plan.
Where is this?
Top of page 5.
Okay.
In recognition of this, you see where I am? Rhode Island has recommended in its Energy 2035 Rhode Island Energy Plan that from a state emission perspective, policymakers should strongly consider in any separate carbon reduction efforts to use consumption-based emissions for the electricity sector. You see where I'm reading?
Yes.
You see then there's a footnote 2.
Yes.
If we look at the bottom, Rhode Island, footnote 2, Rhode Island Division of Planning, Energy 2035, Rhode Island State Energy Plan, State Guide Plan Element, Report Number 50, October 8, 2015, page 150. Do you see that?
Yes.
Now, the portion that Mr. Elmer distributed on Tuesday doesn't have page 150. You may recall, you were here, there was a discussion about putting in the whole October 8 report.
Yes.
Yeah. And we now have copies for everyone. We didn't have them on Tuesday. And this is actually now, and I want to make sure Mr. Elmer agrees, this is actually now CLF 16, the full report.
Yes.
any more copies, Chair.
If everyone could print things double-sided as this is, it would be helpful and appropriate.
So somebody arranges.
This is, but several other documents.
Do you have that, Dr. Roberts?
Yes, I do.
All right, we can go to page 150, the reference from the footnote of the memo that we just looked at. You see a section that starts design or implementation issues?
Yes.
Simply achieving, I'm going to read this, simply achieving ambitious BAU emissions reductions depends at least in part on Rhode Island's continued involvement in RGGI. Under RGGI, Rhode Island generation-based carbon emissions have actually increased. Counterintuitively, this trend attests to the success of RGGI, reflecting how... I'm sorry, I thought I was going too fast. Counterintuitively, this trend attests to the success of RGGI, reflecting how the program is driving broader shifts in the regional generation mix. The in-state growth in emissions can be ascribed to Rhode Island's natural gas-fired power plants, which have begun to operate with greater frequency as higher emitting coal and oil units elsewhere in New England cut back generation. Therefore, from a state emissions perspective, policymakers should strongly consider the merits of planning any separate carbon reduction efforts around consumption-based emissions, at least in the short term. Now, I know Mr. Elmer had the redacted version of Exhibit 16 on Tuesday. Have you had an opportunity before today to read the full version of Energy 2035?
Yes, I have, and I would like to continue my response to that by saying this sentence on page 150 reflects the fact that the rest of the report is in production-based numbers. And further, an earlier draft of this report did not include that sentence.
An earlier draft didn't, but this one does. Correct?
That's correct.
Okay. Was statewide planning being disingenuous when it issued this report?
I cannot speak for the motivations or intent of statewide planning.
All right.
And this is a recommendation, furthermore.
Yes, it is. You are correct. Shall we see what EC4 did about that recommendation?
That's your choice.
All right. The next one.
So this is an energy exhibit for ID 187.
Everybody, you have that in front of you now, Dr. Roberts?
Chairperson, I'd like to make a continuing objection, and I would ask the chair to give me the consideration of having a continuing objection to any additional documents that are going to be offered by my brother that have not been previously furnished to the parties in accordance with Board Rule 1.12C, which requires that any such documents, unless good cause is otherwise demonstrated, were required to be submitted not less than 10 days before the final hearings began.
Why didn't you provide it earlier?
Candidly, Chairperson, because until Tuesday, when we were all witness to what went on with the cross-exam of Mr. Hardy and Dr. Kuhl, we really didn't believe that they were going to stick to this position. It's really that simple. I think you all know what this document is. It completely contradicts the position of CLF and Dr. Roberts with respect to how carbon is accounted for in this state. And frankly, it's not as if they're not aware of it. Dr. Roberts was part of the process. It's really that simple.
Well, what's also really simple is I'm not aware of this. I've never read this. I've never seen it. There is a fairness issue here, and that issue is resolved by the EFSB rules that are duly promulgated pursuant to the Energy Facilities Siting Act and have the force and effect of law. And unless my brother makes a presentation to this board, and this board makes a finding that good cause has been shown, that there was no reason to present this and no need to present this 10 days prior to the commencement of these final hearings, this should
How
not
do you
be
respond
admitted.
to the fact that he just said it's in response to the testimony we heard on Tuesday?
What I will say is that he's seen the testimony of the parties because pre-filed direct and pre-filed rebuttal are already on file. They've been on file for a very long time. If he wanted to counter that, his response, and you know, I don't mean to in any way put down my brother, but his response doesn't make any sense. His response is, I know that's the position they took, but we didn't produce this because we didn't believe they were going to stick to that position. That's just silly. The parties have a right, due process right, to be meaningfully heard, to participate meaningfully in the hearings, and as my brother Mr. Elmer said, trial by ambush is not part of that process. Some parties in this room may be able to quote this memo by heart, but I've never seen it. I don't think this is the way we should be doing this. The rules say it shouldn't be done this way. What I'm asking for is a continuing standing objection to any further documents that are produced during these proceedings that have not been in compliance with Rule 1.12. Whether those documents are produced by my brother on behalf of Invenergy, my brother on behalf of CLF, my brother or sister on behalf of the state agencies, it shouldn't be done that way. And I would like to have a standing objection so that I don't have to go through this each and every time a document is offered.
Chairperson, Invenergy throughout this case has been acutely and exquisitely aware of the fact that things change. Ryan Hardy and John Nyland have filed many iterations of supplemental testimony, extra supplemental testimony, additional extra supplemental testimony. The way documents come in is by attaching them as exhibits to pre-filed testimony. Mr. Blazer's suggestion that he was taken by surprise on Tuesday that CLF's position was as reflected in testimony filed years ago is not persuasive.
First of all, I just want to say, Mr. McElroy, if you want a standing objection, you can have one. But I caution you that I will not remember that.
That's fine. It will be in the record. So I need to protect myself with the record on the possible appeal. That's all. So, thank you.
And we have no objection at all to a standing objection. But I just want to address one further thing. When we talk about fairness and surprise, we learned for the first time this morning that the entire basis of CLF's claim and this witness's claim that Massachusetts utilizes production-based and not consumption-based accounting, carbon accounting, is not even based on the case that they were claiming supported their position. It was based on briefs. It was not based on the law. We now have the opportunity, and they've taken the same position with respect to Rhode Island. What is appropriate, what isn't appropriate, is it consumption, is it production? This document answers that question. I would be, Mr. McElroy, I will grant him, may be surprised by this because Dr. Roberts is Mr. Elmer's witness, not Mr. McElroy's witness. But given the level of detail that Mr. Elmer engages in preparing for this process and how prepared this witness is, particularly considering that this witness was directly involved in the process that led to this document, I find it, to steal a word, disingenuous for Mr. Elmer to suggest that he doesn't know about it.
I do agree that it's a real problem to just bring in documents that have not been previously identified. It's hard enough following a lot of this stuff without having the introduction of the lengthy documents that you then want to ask specific questions on about specific portions of when nobody's had a chance to read it. And generally we do want to see everything beforehand. I do think that these are all important documents, but I think that they all deal with the same information that's contained in the particular rebuttal testimony of this particular witness, which can certainly be addressed in full. I don't know that there's anything specific that is actually rebutted by the meeting minutes. I was hoping that by now we would get into more of a discussion about the substantive parts of the rebuttal testimony regarding the methods of accounting and the issues associated with that. I don't have a problem with this particular document. I haven't had an opportunity to read this yet either. So I think that I'd like to read through it in any event before finally releasing it. But I think that putting in all of these new documents or trying to put them in is taking an awful lot of time away from this case. We want to hear more about the substance of the matters before us. And I hope that after lunch, which we're about to break for, you'll do that. So thank you. We will be back from lunch in an hour.